This is Jackie Weisfield presenting on tort liability for EDL 850. So the quick definition of tort liability is a civil wrongdoing against a person by another person that could be subject to damages. They can be intentional or unintentional, and listed here are some intentional and unintentional torts. I found a defamation and mental distress case that I'm going to be talking a little bit about later, but most of them fall under the unintentional, under negligence, for standard of care and breach of duty. From an education perspective, it's really about keeping students safe and ensuring that as professionals, we act and respond reasonably to reported complaints and safety issues. But we also have to think about, there's a provision about foreseeable events, and so we really have to be proactive as well about student safety and community safety. So the first court case I found was Padilla versus School District Number 1, which is Denver Public Schools. And a quick summary of this case, it was a 10-year-old student with disabilities who gets frightened and agitated when she's pulled, grabbed, or restrained because of medical procedures that she's had in the past. The student's mother came in, talked to the staff about it, and also provided a stroller so that the staff would not have to physically touch the students and risk that student becoming agitated. One day, the student wouldn't eat her lunch, became agitated when employees tried to get her to eat her lunch. So employees put the student in the stroller and moved the stroller out of their line of sight, propped against a closet door. This was their standard procedure for their quiet area for students to be able to refocus. When they did this, the student became violently agitated. The stroller toppled backwards, and the student actually cracked her skull. So the family filed suit against the district for negligence because the placement of the child's stroller combined with the use of the storage room without a window or line of sight created a dangerous condition in a public building. Now, had this happened in my school, I actually think that it would have been dealt with very proactively, that it wouldn't have gotten to this point because the administration is very aware of what is happening in the classrooms in our building. In fact, this year we had some special education issues with one of our severe needs teachers, and she was actually dismissed halfway through the year because of the concerns that the students weren't getting the supports that they needed and that were appropriate for them. And I think just really keeping students at the forefront in any of this work is really important in any professional ethics. So the verdict was that the courts found the district qualified for immunity because the mother's claim was invalid. There was not a positioning issue of the stroller due to construction or maintenance at the school, so the mother's claim that the district was at fault because the building was unsafe was determined to be invalid. So really the thing that the parents were going under was this idea that when a public facility is under construction or maintenance and things have to be changed, that the district can be held liable or the school can be held liable, and that the court said that there was no construction or maintenance, so the school was not liable and the case was dismissed. In the next case, Young v. Brighton School District 27J, this one again involves a negligence piece, and a child slipped and fell in a puddle of water that was on a walkway outside the school that adjoined the school and a playground. And the fall resulted in a head injury of the student. And so the family asserted that the school district was liable because it was a public recreation area because of the playground, and that the walkway was a public facility maintained by a public entity. And there's also an icy walkway provision in Colorado, so the family asserted that the school district was liable because of the icy walkway provision. Initially, the family filed these charges against the elementary school, but dropped the charges and then filed against the school district itself. And again, had this happened in my school, really there would be a conversation between our administration and our school safety and security, the head of safety and security in our district, making sure that everyone is very clear on what needs to be cleared when and what kinds of time frames that those kinds of things need to happen in. I have not, as of yet, seen anything that would make me concerned about that. I get in fairly early in the morning and everything is cleared and ready to go. And so, I wouldn't anticipate that. But again, and if we're being proactive, making sure that before it's rainy, before it's snowy, before any of those things, talking to the facilities and saying, this is what we expect. What have you done in the past? Are we in line? Just making sure everybody's clear on those expectations. So the verdict in this case was that the courts ruled the school district was not liable because the walkway is not in and of itself a public facility, nor is it a component of a public facility. The courts also ruled that the school district was not liable and that the icy walkway provision did not apply in this case. So there were two different courts that this went through. And in the lower courts, they ruled on the icy walkway provision. And then in the Supreme Court of Colorado, they ruled about the public facility piece of the walkway. So in Andrew F. v. Douglas County School District, this is another special education piece, and the family claimed that this public school did not provide a free and appropriate education for their special needs student with autism and ADHD. So the student attended the public school from kindergarten through 4th grade. The parents removed him in 5th grade and sent him to private school. He did much better in private school at the time of the lawsuit. He was a senior being trained in career and tech ed, really had a future, and his parents argued that the individualized education plan provided by the public school was inadequate for their son, and did not provide a free and appropriate education for their son. And so the family wants the public school district to pay for the private school tuition, which was about $70,000 a year for 8 years. And I think really the way that as an administrator that I would be dealing with this and thinking about this is really making sure that students are partners in those IEP meetings and making sure that they feel like they have a voice to say what is working and what is not working and what they think needs to change. And not just allowing for the status quo to be okay. Really advocating for their children and giving parents that voice. And I feel like that's something that we push to do in our school, but is maybe not as prevalent as I would like to see it. So the verdict, this one actually went to the U.S. Supreme Court, and they overturned the verdict of the lower courts. So the lower courts said that the district would not have to pay for the private school tuition, that they met the standard of making some progress, and that was the level of rigor that was expected. But the U.S. Supreme Court said that it was the responsibility of the school district to provide a free and appropriate education for students with disabilities, and that the standard of making just some progress was not a high enough standard. So they want to increase the rigor of that standard. So they remanded the case back to the 10th Circuit Court to be more specific about what making some progress would be and increasing the rigor of some progress. This case is still open. And still going through litigation. The fourth case I found was Munn v. Hotchkiss School, and this one is a private school, and the student went on a school-sponsored trip to China. On that trip, the student was bitten by a tick and contracted encephalitis. Because of that encephalitis, she received, or went through neurological damage, and she was rendered unable to speak permanently. And the family alleged negligence against the school because the school failed to warn that the trip might bring the student into contact with disease-bearing insects. The school called this an unforeseeable event because the likelihood of this happening was low. The school also provided the parents with permission slips and waivers. I think proactively, you just need to know where you're going on the trip and what kinds of things in general are risk factors. So when you go into the woods, there's always the chance that you could come in contact with a tick or other insect, or poison ivy, poison oak, poison whatever. Just making sure that those kinds of things are laid out. Laying out appropriate clothing. Making sure students have bug repellent or are taught to about bug repellent. So making sure that those kinds of things are taken care of. And I think that, again, in our district, we do a pretty good job of making sure that those kinds of things happen. But again, keeping that student at the center. And really, if you would do it as a human, making sure that kids know to do it as well. So the verdict was that the school was found negligent. The court ruled that this was a foreseeable event, and damages were awarded to the family in the amount of $41.5 million. And I think it was really around the permission slips and waivers and not having those kinds of common sense pieces in there about when you go to the forest, expect that you are going to come in contact with wildlife or insects or those types of things. And the last case is Kowalski versus Berkeley County Schools. And this is the one that deals with defamation as well. The student created a MySpace page that was defamatory. The student was suspended for 10 days and socially suspended for 90 days, which meant that she was not allowed to attend any school events that she was not directly involved with. And the student claims that the school violated her right to free speech and her right to due process. The student was suing for damages for intentional or negligent infliction of emotional distress. The MySpace page was found by the student who was targeted and brought to the principal. And the principal consulted with the board before moving forward with consequences. So the student actually engaged in defamation, and she was suing for damages for emotional distress. And the verdict that the courts came up with, the court upheld the suspensions and found that the student's rights were not violated. The MySpace page was a direct violation of the bullying and harassment policy in the student handbook. It was also found to be defamatory, and the court ruled it was foreseeable that it would impact the school since all invitees were students of the school. So she was not allowed damages in this case because the school provided in the school handbook all of these rules and regulations, which is pretty standard and definitely happens at our school as well. So I think really being proactive is really important, and that keeping students at the center and safety of the students at the center is really important when we're talking about professional ethics. And there are just a few pages of the resources that I used in order to put this together and find out more about these different court cases, in case you are interested in obtaining any of those. So thanks for listening.